Caroline?
I just want to add something about the value of being able to view private emails. Before coming to Care One, I was an employment litigation attorney, and we had a case where, and this was prior to the Steingart versus Loving Care Agency, which I'm sure you're familiar with that case. We had a situation where a group of employees up and left, the most valuable employees, and we knew that something was going on. There was something coordinated, and we couldn't find anything. And we were going in for injunctive relief, and I said, let's send out all the computers, and let's have a forensic computer person examine them. And we hit pay dirt on all of their personal emails, emailing with their attorneys about how they were going to orchestrate it prior to the expiration of their restrictive covenants, how they were going to take the largest client, and we found out that the largest client of the company was involved in moving these folks. Needless to say, that really changed the direction of that case. Now, after Steingart, you have to modify your policies a little bit more closely in terms of monitoring private email accounts. But you know, employees communicate on those and communicate things about your organization on them as well. And you should really make sure your policies are very tightly drafted so that you could use it to your advantage in litigation if it comes up.
And you start to think about that, the concept of waiver of privilege, right, which you can scare anyone. Take-Two, before I joined, had the first CEO and second general counsel convicted of crimes in connection with the backdating of stock options. Quite a distinction for a company. And within that, the DA's office had originally gathered emails between the former CEO and his attorney because they were locally stored on his local hard drive. Ultimately, a court in motions during that case ruled that those were in fact still privileged because he was the person who was making the determination as to whether or not there was an allowance for private use of the email system. So it wasn't a waiver, but it was they had to litigate it out.
Our company policy for us is we don't allow any access at work to any social media. We've had too many problems generated, so we don't allow any access on the workplace. We do allow out to the internet to go on to business sites and things that would support the business. In terms of using it in a claim operation, one of the areas, one of the lines of business we're starting to see a lot of benefit is workers' compensation. And we just recently had a case, we write a lot of upscale resorts as part of this program, and we had one of the folks there injure their backs and was looking for complete disability, not going back to work. And during the course of the investigation, one of the folks wrote into us and said, you need to be out here on this field on Friday because he's going to be in a rugby match. So naturally, we took that to his plaintiff counsel, and the case got settled for a lot less. So we're starting to see a lot of benefits. Where we're kind of hesitating a little bit is where do we, you know, as a company, infringe in privacy? We're not quite sure how well defined that is yet, so we're going very cautiously with that.